Madam President, before he leaves the floor, I just want to tell Senator Udall how much I have appreciated having him there in that intelligence room, because he has been a strong advocate for making sure that our country can have security and liberty in those classified meetings, just as he has been here tonight. And it is just great to have you on the committee and to have you as a partner in these efforts. And you are so right when you state tonight that this is a debate that should have begun long ago. And it's a debate that should have been started by elected officials and not by a government contractor. So I very much appreciate your remarks, and I think you made this clear that we're going to stay at this until we get it fixed, and I very much appreciate your leadership. Madam President, as Senator Udall has made clear, these issues are about as important as it gets. When you're talking about how you can secure these bedrock American values, security and liberty, this is right at the heart of what Americans care about most. And for too long, Madam President, my view is the American people have essentially been presented with false choices. Americans have been told you really can have one or the other. You can have your security or you can have your liberty, but you really can't have both. And suffice it to say, Madam President, in the last 8 weeks, as this debate has evolved, I think Americans have come to understand that this set of false choices is not what this debate is all about, and they deserve better. As this debate has unfolded, whether you're in a lunchroom at work or a senior citizen center, or you're looking at a political opinion poll, Madam President, the polls have changed something like 20 points just in the last few weeks, with Americans saying that particularly the bulk phone records collection program is an intrusion on the rights of law-abiding Americans. So whether it's what citizens say at town hall meetings or what they say in the company lunchroom or in senior citizen centers, is Americans have come to understand that these false choices are not what the discussion is all about. Americans have really come to figure it out. And frankly, a big part of the problem in the past, and I documented it last week, is leaders in the intelligence community have made misleading statements repeatedly. It's not just a question, Madam President, of keeping the American people in the dark, which was true, but the American people were actively misled on a number of occasions. And Senator Udall and I have been walking everyone through that. The bulk phone records collection program is often compared to a grand jury subpoena approach. That's about as far-fetched as it gets, Madam President. Even national security lawyers have made fun of that kind of argument in publications like the Wall Street Journal. Very often when I talk to lawyers, the distinguished President of the Senate is, of course, a particularly illustrious lawyer and has taught in the field. I often say when I'm visiting with lawyers or ask for a show of hands, anybody know of a grand jury subpoena where you can go out and have the bulk collection of millions and millions of phone records of law-abiding Americans? Come on up to me and tell me after the meeting is over. I don't exactly get swarmed, Madam President. The reason is there aren't any. And one of the reasons I wanted to touch on these misleading, statements is that just in the last few days, as Senator Udall, touched on, there's really been an effort to take the two programs. One of them is called the FISA 702 program, the PRISM program, which targets foreigners and has useful value. We've made that clear. It could be improved. And I came to that conclusion, Madam President, when I was finally able to get declassified a finding from the FISA court that on at least one occasion the Fourth Amendment had been violated in connection with the use of the 702 program. But even with that, I'm of the view that that provides useful value. But what a number of the leaders of the intelligence community have done is essentially commingled their advocacy of these programs so that 702 and the bulk collection program essentially ride, together, when in reality, 702, which Senator Udall and I have supported, and I think we can improve it with these privacy reforms. In effect, 702 does all the work, and the bulk collection program, which does intrude on the rights of millions of law-abiding Americans, is essentially along for the ride. But you wouldn't know that when you hear these statements from a number of the leaders in the intelligence community when they just say these programs, of course, are what keeps us safe. Now, in addition, Madam President, I thought it was important to briefly start this evening by mentioning that over the last few days there have been a number of comments about whether the Patriot Act has violated the rights of Americans with respect to this bulk collection program. And a number of commentators and others have said, where are the violations? Haven't seen any, violations. Well, the Director of National Intelligence, Madam President, said last Friday in a letter to you and I and Senator Udall and 23 other of our colleagues, is yes, there have been violations of the Patriot Act, when he said specifically that the government had violated court orders on the bulk collection of those phone records. And Madam President, I'm not allowed to discuss the classified nature of that, but I want to make sure that those who are following this debate know that from my vantage point, reading those documents that are classified, these violations are more serious than have been stated by the intelligence community, and in my view are very troubling. So I do hope that senators will go to the Intelligence Committee and ask to see those classified documents, because I think when they read them, I think they'll come to the conclusion I've come, that not only is what was stated by the Director of National Intelligence in that letter that was sent to you and I and Senator Udall and 23 other senators, not only was that correct, but I think that senators who read those classified documents will also come to the conclusion that the violations are more serious than I thought, than the intelligence community portrayed. So let me, if I might, talk a little bit more about why we've spent several years examining this bulk phone records, program. First, I think it's important for citizens to know that the ability to conduct this secret surveillance that lays bare the personal lives of millions of law-abiding Americans, coupled with the ability to conjure up these legal theories as to why this is acceptable, and then have such limited oversight through this one-sided adversarial FISA court, in my view, is an opportunity for unprecedented control over the private lives of Americans. That's really why Senator Udall and I have spent all this time focused on this issue. Now, I thought I'd also tonight and haven't done this before, provide a little bit more history into how we got to this particular place. When I came to the Senate, early on, I had a chance to work with a number of colleagues who really saw the extent of these problems early on. One of them was our former colleague, Senator Russ Feingold. Senator Feingold saw the problems that the Patriot Act posed before they were apparent to many senators, and he and his staff took their responsibility to protect both American security and American liberties very seriously. So in 2007, the two of us came to understand that the Patriot Act was being secretly interpreted to justify the large-scale bulk collection of ordinary Americans' records. And we made it clear that we thought, first of all, that was something real different than what Americans thought was going on. Thought it was real different, for example, than the plain reading of Section 215 of the Patriot Act. And we thought that the language of the Patriot Act had really been stretched beyond recognition, because the language in the Patriot Act really spoke to relevance and a sense that it was relevant to suspected terror activity rather than something that created this enormous leap from what was in the statute that called for relevance to collecting millions and millions of records on law-abiding people. So Senator Feingold and I dutifully set about to write classified letters to senior officials, urging them to make their official interpretation of the Patriot Act public. And we said at the time that for intelligence activities to be sustainable and effective, they have to be based on publicly understood laws and be consistent with Americans' understanding of their own privacy rights. This, in our view, was clearly not the case with the bulk records collection because, of course, the government's official interpretation of the Patriot Act was a tightly guarded secret. So back then, in those early days, we were rebuffed when we made these repeated requests that the intelligence community inform the public what the government had secretly decided the law actually meant. And in fact, there was a secret court opinion that authorized massive, dragnet domestic surveillance, and the American people, by that point, were essentially in the dark about what their government was doing with respect to interpreting an important law. In 2009, as the expiration date for the Patriot Act approached, Senator Feingold and I began to caution our colleagues and the public that our people were not getting the full story about the Patriot Act. At that time, we had the good fortune of having our colleague, Senator Durbin, on the committee, and we all wrote public letters. We authored various articles, the editorial pages of the newspapers. We made statements for the congressional record. We raised issues about this to the extent we could at public hearings. But of course, the Senate rules regarding the protection of classified information limited what we could say. Mr. President, one point that I've tried to make clear is the intelligence rules, the classification rules, don't let a member of the committee tap the truth out in Morse code. You have to comply with the rules, and they are very laborious. And if you don't comply with the rules, you can't serve on the Intelligence Committee and be a watchdog for some of these efforts, which we think go right to the heart of protecting American security and American liberty. So we decided, those of us a small group of us who shared these views, we decided if we wanted to have that opportunity to play that watchdog role, we needed to work within the rules. So we did everything we could, recognizing that you can't tap out classified information in Morse code, to alert the public about what was going on. After a series of short-term extensions, the Patriot Act came up for a long-term reauthorization in the spring of 2011. By that time, Senator Feingold had been replaced on the committee by Senator Udall. He is colleagues know, shares these concerns about the bulk collection of phone records on millions of law-abiding Americans, and we're lucky that he's been a prominent leader in the cause of protecting security and liberty. So during that 2011 reauthorization, Senator Udall and I spoke to colleagues, invited colleagues to secure settings to really lay out what was actually happening, and many of those colleagues joined us on the floor to oppose the extension of the Patriot Act for 4 more years. During that debate, Mr. President, I came to the floor and said, when the American people find out how their government has secretly interpreted the Patriot Act, they're going to be stunned and they're going to be angry. That week, the Senate voted to extend the Patriot Act until 2015, but those who opposed the extension continued the fight in the months that followed. At that time, the NSA was also conducting a bulk email records program, in addition to the bulk phone records program that is ongoing today. Senator Udall and I were concerned about this program's impact on our liberties and our privacy rights. And back in the Intelligence Committee, we spent a big chunk of 2011 pressing intelligence officials to provide evidence of its effectiveness. It turned out that the intelligence community was unable to provide any such evidence. Intelligence agencies had made statements to both Congress and the Foreign Intelligence Surveillance Court that they had significantly exaggerated the effectiveness of the bulk email program. And when Senator Udall and I pressed them to back these statements up, they couldn't do it. The bulk email records program was shut down that year. Our experience with the bulk email records program showed us that the intelligence agency's assessments about the usefulness of a number of these particular programs, even big ones, are not always accurate. Now, that doesn't mean that intelligence officials were deliberately lying. As far as I can tell, in a number of instances, they believed their claims that the bulk email surveillance program was effective, even though, Mr. President, it was actually close to worthless. This was an important reminder that even if intelligence officials are well-intentioned, they can be dead wrong, and that any policymaker who simply defers to intelligence officials' conclusions without asking to see their evidence is making a mistake. As we looked at that evidence, Senator Udall and I found that the claims about the effectiveness of the bulk phone records program also did not seem well supported by the facts. So in March of 2012, we wrote to the Attorney General expressly with this concern. In our letter, we said, and I quote, "In recent months, we've grown increasingly skeptical about the actual value of this intelligence collection operation." We added, and I quote, "This has come as a surprise to us as we were initially inclined to take the executive branch's assertions about the importance of this operation at face value. The Department of Justice unfortunately decided not to respond to our letter, but we continued our efforts to educate the public and to call out senior officials from intelligence agencies and the Department of Justice as they repeatedly made misleading statements about domestic surveillance." In June of this year, disclosures by the Washington Post and the Guardian newspaper revealed the fact of bulk collection to the American people. This sparked the debate that is now ongoing about whether or not hoovering up the personal records of ordinary Americans is the best way to protect our security and our liberty. This debate, as I've indicated, Senator Udall was on the floor, should have started a long time ago, but I'm sure glad, Mr. President, that it is finally happening now. The fact of the matter is that Americans' phone records can reveal a lot of private information. If you know, for example, that somebody called a psychiatrist 3 times in a week and twice after midnight, you know a lot about that person. And if you're vacuuming up information on whom Americans call, when they call, and how long they talk, you are collecting an astounding amount of information about a huge number of law-abiding Americans. The intelligence agencies try to emphasize that they have rules about who can look at these bulk phone records and when. But, Mr. President, I want to emphasize this because I think after all of the talking on cable and the talking heads on TV, I want to emphasize none of these rules require the NSA to go back to a court to look at Americans' phone records, and none of these rules erase the privacy impact of scooping up all of these records in the first place. On top of that, as I indicated at the beginning, there have been a number of serious violations of those rules. For the senators who got the letter last Friday, you know that. I want to tell all the other senators on both sides of the aisle that the violations, as I've touched on tonight, were more serious, a lot more serious than the public has been told. I believe the American people deserve to know more details about these violations that were described last Friday by Director Clapper. Mr. President, I'm going to keep pressing to make more of those details public. And Mr. President, it's my view that the information about the details, the violations of the court orders with respect to the bulk phone record collection program, the admission that the court orders had been violated has not been, I think, fully fleshed out by the intelligence community, and I think considerable amount of additional information can be offered without in any way compromising our national security. Now, if the impact on America's liberties wasn't bad enough, it's made even worse, Mr. President, by the fact that this program, when we've asked and we've asked and we've asked, does not seem to have any unique value. And I'll explain briefly what it means. Mr. President, I would ask for, let's see, how about 7 additional minutes? Ask unanimous consent.
Without objection.
All right. And I'll see if I can beat the clock here because I know colleagues are here as well. And in fact, Senator Baldwin has been a great advocate for liberties and showing that liberty and security are compatible, both when she was a member of the other body and here when she was part of our group, and I thank her for it. Mr. President, intelligence officials can only point to 2 cases where this program, the bulk phone records collection program, actually provided useful information about an individual involved in terrorist activity. In both of these cases, the government had all the information it needed to go to the phone company and get an individual court order or an emergency authorization for the phone records they needed. In both of these cases, the individuals who were identified using these phone records were arrested months or years after they were first identified. But if government agents had felt that the situation was urgent, they could have used emergency authorizations to obtain their phone records more quickly. I'm glad both of these cases resolved the way they did. I'm proud that our intelligence agencies and law enforcement individuals were able to identify and arrest those who were involved in terrorist acts. In one case, 4 men in California were arrested. We're sending money to a militant group in Somalia. In the other case, a conspirator of Mr. Zazi, a few months after Zazi's plot was disrupted, one of those individuals was arrested. These men committed serious crimes. They're now being punished with the full weight of the justice system. What I don't see, however, Mr. President, is any evidence that the U.S. government needed to operate a giant domestic phone record surveillance program in order to catch these individuals. I have seen no evidence, none, that this dragnet phone records program has provided any actual unique value for the American people. In every instance in which the NSA has searched through these bulk phone records, it had enough evidence to get a court order for the information it was searching for. And getting a few hundred additional court orders every year would clearly not overwhelm the Foreign Intelligence Surveillance Court. The intelligence agencies may argue that collecting Americans' phone records in bulk is more convenient than getting individual court orders, but convenience alone does not justify the massive intrusion on the privacy of ordinary Americans. I believe it's vitally important to protect the safety and the liberty of our people. I don't see any evidence that this program helps protect either. That ought to be the standard of any domestic surveillance program. If the bulk collection program doesn't protect privacy or security, then it ought to end, plain and simple. The executive branch simply hasn't shown anything close to an adequate justification for this massive dragnet surveillance that has compromised the civil liberties of millions of Americans. I'm not sure they ever could, but I'm confident that I haven't seen it as yet. Now, Mr. President, let me close by way of saying that over the last few weeks, we've seen extraordinary support for reform. Last week, over 200 members of the other body voted to end the bulk phone records collection program, and a number of the members who voted against ending it at that time made it clear they have serious concerns they want addressed. So there are going to be more votes, Mr. President. Make no mistake about it, there are going to be more votes on whether to end the bulk collection of phone records on law-abiding Americans in the 113th Congress. And there are going to be efforts to reform how the entire U.S. surveillance system works. One of the most important reforms will be to make the significant rulings of the Foreign Intelligence Surveillance Court public, which is a goal that I've been pursuing for several years. Additionally, I believe Congress needs to reform the process for arguing cases before the court. Right now, the government lawyers walk in with an argument for why the government should be allowed to do something, and there is no one to argue the other side. That's not unusual if a court is considering a routine warrant request, but it's very unusual when a court is doing major legal or constitutional analysis. I believe that Congress needs to create a way to advocate for the public, a public advocate, to argue cases before the court, because making this court more transparent and more adversarial is a way to ensure that Americans can have security and liberty. And of course, the relevant provisions of the Patriot Act itself will be expiring in 2015. I don't think there's any reason for the administration to wait for Congress, to act. The executive branch can take action right now. They can and should continue to obtain the records of anyone suspected of connections to terror or other nefarious activity, and at the same time, they can restore protections for Americans' Fourth Amendment rights. I'm very interested in working with the administration on these issues, but they can move of their own volition. So one way or another, Mr. President, we are going to stay at this until at this unique time in our constitutional history, we have revised our surveillance laws so that we can have security and liberty. And colleagues are coming to this cause. Senator Blumenthal has particularly recommended a number of constructive FISA court changes over the last few months. I hope colleagues will support that, and I hope they will see at this unique time in our history that it's critically important that these surveillance laws that I and Senator Udall have talked about tonight can be reformed, and we do it so as to protect those bedrock American values, both security and liberty. With that, I yield the floor.